Good morning. Welcome back to the Retirement Report. I'm Hank Parrott, your host. With me today is my good friend and special guest, Russ Cook, with Russ Cook & Associates over in Brentwood, Tennessee. Russ is a board-certified estate planning attorney. I've been working with Russ for over 15 years, does excellent work, and I've been very pleased both for my clients who've been very happy with the work he's done for them. We've had, over so many years, in fact, I've had clients that have passed on that we've done that kind of planning for and got to see how well those documents performed when the time came that they were needed. So can't speak highly enough of Russ in that regard. One of the things that when I do estate planning with my clients, and by that, what I'm talking about is when we get into the whole retirement plan and we're looking at all the things that are needed. I'm always checking in. Okay, do you have wills? Do you have powers of attorney? Do you have maybe a trust? What is your situation? By the time we get to that piece, which typically it's the latter part of the planning, though sometimes I have new clients come in and the first thing they want to address is the estate planning. That's the area they're most concerned about. So of course we'll jump right into it. We'll have Russ come in and meet with them, talk about, together we'll get into the estate planning piece. I'll usually go into talking and finding and basically doing an assessment of the kind of needs they're going to have. So depending on if they have a special needs child, if they have maybe someone in the family that's not so good with money that's going to be receiving some inheritance, and how to deal with those things. So we answer those kind of questions. We line up and see what's going to be the type of planning they're going to be needed, provide them some assistance there in working through and asking the right questions to help them develop that idea, and then bring Russ in and we nail it down as far as the kind of documents they're going to need, the different types of trusts there are, whatever it might be for their needs. And if you'd like to get that type of planning as well, I'm going to give you an opportunity for that. For the first 10 callers to my office this morning, the number is 615-376-5325. We'll have you come in and we'll do a comprehensive financial plan for you. That includes all the retirement planning that I talk about. That's the investment analysis. We talk about Social Security, about Medicare, healthcare costs and retirement. We get into tax planning. We talk about Roth conversion strategies, among other things, if that might be something you would benefit from. We talk, so in addition to tax-efficient income in retirement, tax-efficient investing, so many areas and topics we cover, and of course estate planning being one of the other topics, and the one, of course, we're talking about today. So if you'd like that kind of planning, and it's going to be more than one visit typically, 2 or 3 visits, but at no charge. I want you to see the value we can bring to you, my firm can bring to you, and if it's a good fit, maybe you'll become a client as well. 615-376-5325. First 10 callers. Tess is standing by. She'll get your information. She'll send you out a checklist of things to bring to your appointment with me. And when you come in to see me, I'll give you a free copy of my book, 7 Steps to Financial Freedom in Retirement. And of course, Chapter 7 talks all about the estate planning process as well. So, Russ, one of the things just before the break, we were talking about conservatorship. So what I want to go through, walk people through, is what's involved. So if I have that kind of situation where husband or wife has become incapacitated. Let's say in this situation that the husband, we'll go in a traditional route here. The husband's had a stroke, God forbid, but he's had a stroke, and they got a lot of money in their retirement accounts. That's the biggest asset. Wife maybe needs to access those monies to be able to help cover these costs, these additional medical costs and stuff, maybe through this period. Other things that go around that, caregivers, who knows what it might be. And yet she doesn't have a power of attorney. Mm-hmm. And now she needs to go get an attorney.
Yes. In order to be able to access those funds, and we're talking about the funds that are in the institutionalized spouse's name alone, which is typically the retirement accounts, because you can only hold that in one person's name. The retirement custodian, I guess, will not allow the spouse to just access the funds without having some sort of documentation giving her authority to do that. And if she doesn't have a power of attorney, which can give her the authority to do that, then she has to get authority through the court. Now, the only way to get authority through the court is to file a conservatorship petition. It involves getting an attorney, preparing the documents, advancing the costs, because you can't access the retirement account to pay for it just initially, advancing the costs, and then going through the process of of having the court get involved by appointing an attorney for the court to assess whether or not the person that you're getting conservatorship over really needs one, and bringing all of what's going on in your family to the public light, because then you're bringing in other folks that have to do analysis and evaluations. And then once you're able to prove that your spouse is indeed incapacitated, then the court, assuming that you're the best person, will grant you authority to access the accounts. And this could also bring up challenges from other people. Now, I know it may not sound a little crazy when you're talking between spouses, but it does happen where maybe the parents of the institutionalized spouse, they want to control things. Now, that actually happened in the Terry Schiavo case with respect to health care, where the spouse wanted to make a decision concerning her health care, and the parents wanted to make a different decision, and they ended up taking that to the Supreme Court because of the fact that there were no documents in place. Well, even with financial matters, you're opening up the door for other people to get in and say, hey, maybe you're not the best to manage his assets, maybe it's me. So you don't want that. You want to go ahead and take care of it in advance. Costs are expensive, you know, and then you have to account to the court each year for what you're doing with the funds, which is another expense, because then you've got to keep the attorney on retainer to be able to do that.
So imagine that. You're having to hire an attorney. You may need a bookkeeper or accountant to help you as far as the reporting to the court and the forms that need to be filled out and everything there, of course. Getting the conservatorship, you're talking thousands of dollars, by the way. I would say, what, $3,000 to $5,000 probably? For
minimum, yes.
At least that. So at least $3,000 to $5,000 plus. It could take 3 to 6 months. Maybe you can get it expedited if there's a real urgency or emergency situation. But these are, imagine having to go through all that and then have to report to the court what you're doing, again, with this family asset. It's crazy, all because you don't have a document that is so inexpensive in relative to that to get taken care of as far as these powers of attorney go. Now, the 5 essential documents, we'll take that a step further. We'll talk about, with regard to trust, for instance, what's involved there. All right, with a trust, now if you've got a trust set up and you've got assets in the trust, you've got some additional ease, if you will, when it comes to administering or taking care of matters. Not the retirement, or excuse me, yes, the retirement accounts, you're still going to need the powers of attorney and everything for, but for other assets and other things that you may own, this is where a trust can add another layer, because it's going to give you even more ease when it comes to administering an estate or taking care of things. As I mentioned earlier with my client who had the stroke, his brother's able, because he's had a lot of assets, not just in retirement accounts, his brother's able to access those because we have those in the trust. We have the brother set up as a successor, able to step in just this kind of situation and help his brother take care of paying his bills and stuff. When it comes to expense, the big expense is in not having the planning done, not in doing the planning. You know, it's so much cheaper to get it done up front and get that handled now than it is when something happens and you're scrambling around trying to come up with, you know, what is becoming an emergency plan at that point, and it's always going to be more expensive. One of the things, Russ, when we get into the planning piece then, 5 essential documents, so we've talked about the powers of attorney, living will, which kind of fits in with that as far as making your wishes known. If you're, you know, end of life, in a coma, what do you want to have happen? Do you want your, basically, you want your death prolonged, which is what it comes down to. Talk about the qualifiers a little bit on that, and then we'll get into the trust thing. But the qualifiers, when sometimes people worry that if they sign off such a document, they're somehow, it's like they're going to let me die when they could save me, kind of thing.
No, the documents that we've been discussing, the power of attorney for health care and the living will, use a very key term in discussing these decisions. It's called I authorize. So it's not saying that someone has to make these decisions in a very strict way. What it's doing is it's giving the person that you're naming the power to make all these decisions based on your wishes. Now, I like that flexibility because it allows for changing circumstances. Sometimes I'll hear someone say, oh, Grandma had a living will, but we ignored it. Well, you really technically did not ignore it. What you did was you had the power to make the decision to take her off of machines. You just decided not to exercise the power. So The living will still gave you the authority, but it didn't mean that you had to actually exercise it. So that's been something that we've been able to explain to clients, and they really like the flexibility. Now, if you absolutely want to dictate in advance how you're going to be, those situations are going to be addressed, there is another document called an advance directive where it talks specifically about conditions that you would consider unacceptable and treatment that you would not want if you were suffering those conditions. Not all my clients sign those documents because they are afraid of the fact that they are very definite. But if you're the type of person that really wants to make those decisions in advance, there is a document for you, and that is the advance directive.
Okay. You know, this is one of the areas when we get into planning, just getting all these things handled. All right. Sometimes we procrastinate. We think, you know, well, there's time for that. Well, there's not always time for that. You know, you don't know when something, just like we were talking about with strokes. I've had clients that have had things happen to them in their 50s even, and, you know, total shocker that the, 20, 30 years ahead of when you might normally see something like that. So we don't know. Better to have it handled, have that peace of mind of knowing it's done. And now comes into the other part when it comes to planning. We're going to talk about the difference between a will and a trust. This is one of those areas when we talk about probate, for instance, is one of the areas you get into. But there are other factors that come into play too. So one of the things, Russ, when we're talking about the difference between a will and a revocable trust, I'll let you do a basic definition of that to start.
Okay. One thing just to kind of set the stage, the will and the living will tend to be confusing because they both say will. Right. Living will is really just a directive to the hospital on terminal condition. A will is a document that you sign that governs the distribution of your assets when you pass away. It's not effective until you pass away, and it's not effective until the court blesses it as your last will and testament. That process of getting the court to bless it is what we call the probate process. A revocable living trust is a document that does the same thing as a will. However, instead of going to the court and getting it blessed to get it going, you're basically putting it in effect when you sign it. So a lot of folks like the fact that they're not having to force their heirs to go to court in order to have their documents become effective. Now, both the revocable trust and the living will address how your assets are distributed when you pass. Again, we mentioned the revocable trust can also help allow someone to take control if you become incapacitated. The will doesn't offer you that option. The revocable trust, though, when you pass, will then dictate how the successor trustee, the person you name to make sure that your assets are transferred in your wishes, takes over and does that for you, pays your final debts and expenses. They don't have to get appointed by the court. The will appoints an executor. That executor does have to be appointed by the court. They go ahead and do the same thing, but then they have to go back to court after everything is done and file paperwork to close the estate. So you can see the the difference between the two is really the process.
Right.
You know,
this is one thing. If you think about probate, one way to look at probate is this is an area where you're taking that will is going into for a judge basically to help and your attorneys and all the process itself is that of then getting those assets the way you've laid out in the will. I want my stuff to go to this person or that person or some maybe to this charity or this church or whatever it is. Whatever your instructions are, the court basically is going to make sure with your executor and of course the attorney that you're having help you with this, that those things get done. With a trust, however, it works a little differently, and we're going to talk about that after this break. We're going to show you the difference between those and how and what the advantages and potential disadvantages can be to either course of action, whether it's a will, trust, what probate, a little more about what probate's about. But first a break. Join us here. We'll be right back on the Retirement Report.